Hello, I'm Janan Jarrah with eLaw Alliance.
And I'm Peter Poon with eLaw Alliance.
And today we wanted to talk to you about common questions we get as family law lawyers about family law, parenting, and custody. We get a lot of those types of questions, so today we're going to answer just a few of those. Peter, what are some of the questions you often run into about this area?
So Janan, what are the laws that govern the parenting matters?
So in Alberta, there are two primary pieces of legislation that decide things related to family law. That would be the Divorce Act and the Family Law Act. So those two acts are primarily what decides issues surrounding family law and divorce rights.
And what are the differences between the two acts, the Divorce Act and the Family Law Act?
Well, there is a lot of overlap between the two legislations. So they deal with similar issues, including things like child support, custody, parenting. So there's a lot of overlap. However, the Divorce Act is intended for people that are married. So they can seek remedies under the Divorce Act if they're married. If you are not married, you would then be covered under the Family Law Act. And also, if you're married, you could use the Family Law Act. So the Divorce Act requires that you be married, but the Family Law Act doesn't require that you be married. And even if you are married, you can still utilize the provisions under the Family Law Act.
So does that mean that if I'm married, the only act that I can utilize would be the Divorce Act?
That would be, yes, the primary act you utilize.
What is the difference between joint custody and sole custody?
So when we talk about the word custody, really what we're talking about is decision-making authorities. So if one parent has sole custody, really what that means is that they have sole decision-making authorities. If somebody has joint custody, that means decision-making authorities are shared between the parents. And when I say decision-making authorities, I'm talking about a variety of things, including where the children go to school, where they live, who they associate with, their cultural upbringing, things of that nature.
There's a lot of terms, and my clients are always confused about these various terms. Can you explain to us what the difference is between custody and parenting?
So when we're talking about custody, again, we're talking about decision-making authorities, whereas when we're talking about parenting, that usually specifically denotes parenting time, so the actual time that you spend with your kids. If you are the day-to-day parent, that means that you've got more than 50% of the time with your kids as their primary caregiver. If you have reasonable and generous access, then that's another type of parenting time.
What happens if my ex won't let me see my kids?
So if your ex won't let you see your kids for no good reason, that's definitely something that you can take to the courts to try to get a remedy there. Generally speaking, it's not appropriate to keep a parent from their kids, and courts don't like to see it when it happens. So if the other parent is preventing you from seeing your own child for no good reason, take them to court.
If I don't pay child support, do I still get to see my kids?
You still have to pay child support even if you don't see your kids. Those two issues, child support and custody or parenting, are independent of each other. So even if you don't get to see your kids, the obligation is on you to continue to pay child support to them.
I get asked this a lot by my clients. What does the court generally look for when they're considering parenting time?
So the primary principle in family law or divorce law when it comes to kids is what is in the best interests of the kids. That's the prevailing principle. So that's going to guide judge's decision anytime we're dealing with children. There are other principles that come into play. For example, under the Divorce Act, there's a principle called maximum contact, which generally speaking means that courts are encouraged to, as much as possible, have each parent have as much time with the kids as possible, as long as it's in the child's best interest. So we always come back to best interest as the prevailing factor in deciding issues that are in dispute around children.
My spouse and I are separated now, and does she get to take my children out of the province?
If she has your consent to do so, yes, she can take the kids out of the province, but meaning relocate them. But if she doesn't have your consent, the only way for her to be able to take the kids out of the province to relocate them would be through a court order, through convincing a judge to allow the move. And judges decide these types of, we call them mobility applications, based on best interest of the child and whether or not the child has a substantial connection to their original home.
And now that we're separated, who gets to make the decisions for our children?
Normally, the decisions are shared. Oftentimes, people have joint custody, so they share decision making, but that's not always the case. Some judges will dictate that one parent has all the decision making authorities, or even some of the decision making authorities. So it can vary depending on the case.
And at what age can a child decide which parent that they want to live with?
Generally speaking, the older the child is, the more likely a judge will agree or allow them to decide for themselves which parent they want to live with. And when I say older children, I'm talking about teenagers. So if you have for example, a 16-year-old or a 15-year-old, generally speaking, absent any kind of mental health issues, that child is likely going to be able to decide for him or herself which parent to live with.
For example, if my son's 5, and what if he keeps telling me he doesn't want to see his mom anymore?
Well, when a child is really young, like 5 years old, they don't get to make that decision. So even if they're throwing tantrums during pickup and drop-off exchanges, it's not going to be an excuse for the other parent to say, well, 5-year-old Johnny doesn't want to see dad, so I'm not going to force him. The fact of the matter is, kids that young don't get to decide. The parents will have to come to an agreement on what the parenting is going to look like. If they can't come to an agreement, then a judge will decide for them based on what the judge thinks is in the best interest of the child.
My ex's parenting style is very different than mine. What can we do about it, and who gets to decide how my kids are being raised?
Generally speaking, the parent that has the child in their home and is exercising parenting time gets to decide what they do with the child. And the other parent shouldn't interfere with that. So if during dad's parenting time he wants to take the child to a baseball game, then mom shouldn't be in a position to interfere with that, generally speaking. So whoever has the child usually gets to make decisions with respect to the child during their parenting time.
And that's even if I don't like their parenting style.
That's right. If mom and dad are very different in terms of their parenting style, you kind of got to take what you have. You don't get to dictate parenting style to the other parent when it's their parenting time, and vice versa.
What if I have a lot of concerns about my ex's parenting style?
If those concerns are legitimate, for example, you can substantiate that there's abuse going on or neglect or abandonment, you can bring those types of concerns to the courts to alert the judge in an effort to vary parenting time or terminate aspects of parenting time. But that requires proof, and it's a pretty high threshold for that. Normally, judges like to have the child interact and be a part of each of the parents' life. So if you've got proof of some sort of concerning behavior, then that would be something you could bring to court.
Would I be able to get a lawyer for my own children?
In some cases, yes. It's not unusual for children to have their own lawyer. So yes, that is an option. If the parties are so very positional and they are not agreeing on anything, sometimes judges will order that the child have his or her own lawyer, and then that lawyer will speak for the child.
And who usually pays for their lawyer?
So I've often see it occur that the judge will order the parents share the cost of the lawyer, but that's not always the case. Sometimes judges will also order that one parent take on the cost. And legal aid does cover children's counsel, so you can get a lawyer at a much reduced rate if you go through legal aid.
Can I have my own lawyer represent my children as well?
No, definitely not. That would be a conflict of interest. If the child is going to get a lawyer, definitely that child would get their own independent lawyer, independent of mom's lawyer or dad's lawyer.
I hear this term a lot, and my clients get confused about it. What does supervised parenting time mean? Does that mean someone's looking over my shoulder when I'm with my children?
Essentially, yes. Supervised parenting time is what usually occurs when something concerning has come up that would justify somebody watching the parent the child. Sometimes a supervisor could be a family member, a friend. In other cases, you can hire outside agencies and pay them to supervise a visit. Supervised parenting time is not awarded in all cases. The threshold to obtain it is pretty steep. You have to be able to justify and give a good reason to limit a parent's parenting time in such a fashion.
I I mean, I praise myself as a very good communicator. What if my ex is very difficult to communicate with?
Oftentimes when parties are not able to get along and even communication is tough, what we often suggest is that their communications be in the form of an email, text message, so that it's written, so that they could each be able to take some time to think about what they have to say before they communicate it. Also with written communication, you can use it against the person in court if you're trying to show that they are being impossible when it comes to communication. I've seen it occur where a judge will order that the parties are to communicate through an application called Family Wizard. So that's one example of a type or a method you can use when you can't really get along with the other parent but have to communicate with them anyhow.
Now, are there any other options than litigating it and going to court and we're all, saying things to each other? Are there any other options for us to resolve our family law matters?
Certainly. So litigation, battling it out in court, oftentimes is the last option. You don't want to necessarily go to court right off the bat without even trying to come to an agreement first. Litigation is very expensive. It's risky in that you don't really know what the judge is going to decide. And judges do expect that the parties will attempt some type of alternative method of resolution before they jump into battle in the courtroom. Some examples of out-of-court alternative dispute resolutions include things like JDRs, which stand for Judicial Dispute Resolution. This is something you can get through the court where it's an informal meeting with a judge who will go over your case and give an opinion on what he thinks he would do with your case if he were hearing it. That judge doesn't have the authority to grant any type of orders, but it's still a good method so that the parties can see how their case might unfold in front of a judge or what might happen with their case if they took it to court. So that's one method. There's something relatively new before the Alberta Court of Queen's Bench called the Early Intervention Case Conference. It's another form, a 1-hour hearing with a judge who will hear the case, not make any kind of decisions, but at least give opinions on what he or she thinks the party should do. And sometimes these avenues are very helpful and can often help parties come to some agreement on issues.
Thank you. That was very informative. That's all the questions we have for today.
Okay, stay tuned. We'll definitely be coming up with more videos. And if you want specific legal advice, don't take this video as legal advice. We're just mainly speaking in generalities. But if you are looking for free telephone consult, give our office a call. We'll give you tailored legal advice.